that the applicant's case was mainly hinged on the infringement of the right to a fair hearing as enshrined in Article 28 of the Constitution, as discussed in the Kazinda case. In the Kazinda case, 3 justices of the Court of Appeal held that offences with which Mr. Kazinda was charged fell within the definition of the offences of the same character and could adequately have been joined in one trial. The numerous trials for offences similar in character amounts to a deprivation of the right to fair hearing and contravenes Articles 28(1) and 9 of the 28(1) and 9 of the Constitution. That failure to adhere to the above provisions of the Constitution would lead to the increased use of judgment against an accused person, which infringes on the right to a fair hearing. However, this court is unable to rely on any arguments referring to that case because on the 12th day of February 2021, the Supreme Court in Constitution Application number 27 of 2020, the Attorney General versus Kazinda Joffrey issued an order staying the execution of the judgment and orders in Constitutional Petition number 30 of 2014, pending the hearing and the determination of the intended appeal by the applicant. Honorable Elias Lukwago invited this court to find that joinder and consolidation are just semantics, but they have one and the same meaning. I respectfully disagree because in practice, they actually mean different things and cannot be performed in the same way. Whereas in consolidation, 2 or more distinctive case files are brought together and handled as one, joinder means having 2 or more persons or offences on one and the same charge sheet or indictment on this, or indictment on this and on the same summary of the case. It should also be noted that under Order 11, Rule 1 of the CPR, consolidation is permitted when 2 or more suits are before the same court. In light of the above, I therefore agree with counsel for the respondent that consolidation of criminal cases is alien to criminal law and procedure because it is not provided for in the laws. This would ordinarily dispose of this application at this stage. However, Honorable Ebya Ssegirinya and Honorable Elias Lukwago invited this court to exercise its inherent powers under Section 17(2) and 33 of the Kk Act and order for the consolidation of the two case files in order to prevent abuse of court process. Having listened to the submissions of counsel for the applicant and the court decisions they relied on, I formed the view that whereas the application seeks a consolidation of the 2 case files, they actually intended to mean joinder of offences and persons on one indictment and not consolidation. This is because in their submissions, when asked how consolidation would be done, Honorable Ebya Ssegirinya explained that the count of murder in Rengo CRB 203 of 2021 would be added on the indictment in Masaka. In Masaka CRB 605 of 2021, and the 2 would be handled as one. This is clearly joinder of persons and offences and not consolidation of criminal matters. In the spirit of administering substantive justice, this court will exercise its discretion and treat this application as if it was an application for joinder of offences and persons so as to conclude it on its own merits. This therefore takes me to the second issue, which I will rephrase as follows. Whether the persons and offences in Rengo CRB 203 of 2021 can be joined on the charge sheet or indictment of Masaka CRB 605 of 2021 that is before this honorable court and be handled as one. Honorable Elias Lukwago submitted that Masaka CRB 605 of 2021 and Rengo CRB 203 of 2021 arise from a series of the same transactions and therefore should be handled together in order to avoid abuse of court process. It was his contention that the 2 cases are inextricably intertwined so much that one cannot be divorced from the other. He gave a chronology of the events and submitted that the charges in Rengo CRB 203 of 2021 were as a result of a series of murders that happened in Greater Masaka. And in came after the applicants had been granted bail by the High Court in Masaka. In Masaka, Sierra B 605 of 2021. He wondered why Rengo Sierra B 203 of 2021 did not come first, since it indicates that the offense was committed on 2nd August 2021, which is way before the other murders which are said to have happened on the 23rd August 2021. The father argued that Rengo is part of Greater Masaka, and the offense in Rengo CRP 203 of 2021 is part of the series of murders that were happening in Masaka at the time and are acts of terrorism. On the other hand, Chief Secretary Richard Bobi, while citing sections 23 and 24 of the TIA, which regulates framing of charges in criminal matters, vehemently opposed the joint of offences and persons. He submitted that the offences and the persons in the two case files cannot be joined in the same indictment. Otherwise, there would be a misjoinder and resultantly a miscarriage of justice. He contended that the parties in the two cases are completely different for the applicants, except for the applicants who appear in both. He also argued that the offences were committed at different times, in different places with different facts and different motives. He further argued that whereas in Masaka Sierra B 605 of 2021, the motive of the murders was terrorism, in Rengo Sierra B 203 of 2021, the murder was an isolated incident and the motive is unknown. He finally submitted that allowing joinder would mean charging all the people afresh and committing them for trial and let them undergo a fresh prepared process which would cause more delay. In order to resolve issue 2, this court will be expected to answer 2 questions, namely, 1, can the offences in the 2 case files be joined and charged in one charge sheet or indictment? And B, or 2, can the persons in the 2 case files be joined in one charge sheet or indictment? The law governing joinder of counts in the High Court is provided for under section 23 of the Trial Indictments Act, and it provides as follows. 1, any offences, whether felonies or misdemeanors, may be charged together in the same indictment if the offences charged are founded on the same facts or form or are a part of a series of offences of the same or similar character. Whereas more than one offence is charged, number 2, whereas more than one offence is charged in an indictment, a description of each offence or charge shall be set out in a separate paragraph of the indictment called count. Applying the above law to the facts of this application, I find that the offence in the charge sheet of Rengo, CRB 203 of 2021, is murder, and I believe that it is of the same or similar character with offences in the charge sheet of Masaka CRB 605 of 2021, within that meaning of section 23.1 of the TIA. This would therefore mean that the offences may be joined together in the same charge sheet. The first question, therefore, is answered in the affirmative. The other question is, can the persons in the 2 case files be joined in one charge sheet or indictment? Joinder of persons is provided for under section 24 of the TIA, which provides that the following persons may be joined in one indictment and may be tried together. 1, persons accused of the same offense committed in the course of the same transaction. 2, persons accused of an offense and persons accused of abatement or of an attempt to commit that offense. 3, persons of more offenses than one of the same kind. That is to say, in brackets, that is to say, offenses punishable with the same amount of punishment under the same section of the Penal Code Act or any other written law committed by them jointly within a period of 12 months. And 4, persons accused of different offenses committed in the course of the same transaction. It goes on up to 6. Considering the facts in the instant case, the only provision that would be applicable is section 24, subsection 3 of the TIA. If the applicants were the only accused persons appearing on the charge sheet of Rengo CRB 203 of 2021, then they would safely be added to the charge sheet of Massacre CRB 605 of 2021. This is because the applicants would be, and I quote, persons accused of more offenses than one of the same kind, brackets, that is to say offenses punishable with the same amount of punishment under the same section of the Penal Code Act or of any other written law committed by them jointly within a period of 12 months. However, there is another accused person, namely Ssewanyana Wilson alias Nyonga Tony, on the charge sheet of Rengo CRB 203 of 2021, which makes the joined out persons impracticable. Besides, Massacre CRB 605 of 2021 also has 5 other accused persons in addition to the applicants. Had it been that A3 also appears as one of the accused persons in Massacre CRB 605 of 2021, or there were no other accused persons on the charge sheet of Massacre CRB 605 of 2021, then the joined out persons will be possible. However, A3 is a total stranger to the case that is currently before this court. As such, bringing A3 to the case before this court with the accused persons is not connected to in any way, and for charges is unaware of, would be a misjoinder of persons. In light of the above, therefore, it is clear that the persons in the charge sheet of Rengo CRB 203 of 2021 cannot be safely joined on the charge sheet of Massacre CRB 605 of 2021, thereby answering the second question in the negative. Having made that finding, I also find that failure by this court to order for a joinder of counts and persons in the 2 case files that are the subject of this application does not in any way violate the applicant's rights to a fair hearing and is not prejudicial to them in any way. The 2 matters can be safely handled separately. Counsel for the applicants emphasizes that charging of the applicants in 2 separate files is an infringement of the right to fair hearing as enshrined in Article 28.1 and subclause 1 and 9 of the Constitution, which provide for the right to a fair and speedy trial and the right against double jeopardy. Though the Supreme Court has stayed the execution of the judgment of the Kazinda case, on which counsel for the applicants placed their submissions for this argument, I believe this court has a duty to give its view on the right to a fair hearing as enshrined in Article 28, clause 1 and 9 of the Constitution in light of the facts of the instant case. My view is that charging the applicants in 2 case files does not deny them their right to a fair and speedy trial, because as this court was informed, in both case files, the accused persons have already been committed to the High Court for trial. Counsel for the applicants also contended that charging the applicants in the 2 case files amounts to double jeopardy. Double jeopardy is provided for under Article 28 and Clause 9 of the Constitution, provides as follows. A person who shows that he or she has been tried by a competent court for a criminal offense and convicted or acquitted of that offense shall not again be tried for the offense, or for any other criminal offense of which he or she would have been convicted at the trial of that offense, except upon the order of the Superior Court in the course of appeal or review proceedings relating to conviction or acquittal. Clearly, in the facts before this court, there has been no conviction or acquittal of anyone. Therefore, this leaves us with the aspect of courts or for any other criminal offense of which he or she could have been convicted at the trial of that offense. It is my view that it cannot be said that the applicants could have been convicted of the murder in Rengo CRB 203 of 2021 in the trial of Massacre 605 of 2021 for it to amount to double jeopardy. This is because the offenses and the persons in the 2 cases are different. I also need to observe that sections 23 and 24 of the TIA that regulate the joinder of offenses and persons use the word may and not shall, leaving it at the discretion of the Director of Public Prosecution to determine which offenses and persons to jointly charge. This discretion may only be interfered with upon satisfaction that there was abuse of the legal process. Counsel for the applicants vehemently argued that charging the applicant separately was in abuse of the legal process. However, no evidence was adduced to the satisfaction of this court to that effect. In conclusion, this application hereby fails and is accordingly dismissed with no order to post.
My Lord, we oblige that before we go this step play. I'm just putting counsel on record. It's not something major. It may be recorded that the Honorable Ssewanyana Byongedde came in here to proceed. She did put on record as present. Thank you.
Thank you to both parties. Anything else you want to say?
Yes, the last one, my Lord.
Mr. Moizi,
Yes.
that was it.
Yes, that was it. Not in the previous ruling, it was
Apologies for that.
my Lord, we have the pending application for bail before you. Whereupon, due to the decision just handed down to us this morning, leaves this court to the discretion on whether to fix that application or not.
You want me to fix it?
Yes, we would prefer that the same be fixed. Would be obliged.
You want me to fix a bail application? Mr.
Tulia Musima.
You want me to fix a bail application? Because I don't want us to waste time. If I have said I don't have the Masaka file and I cannot pick it from my colleague, how do I handle a bail application for a matter that is in Masaka? Considering what I have already done. I just don't want us to waste time. And let's be honest as a court and save time. Because you see, we are saying this case should be handled expeditiously. And I am committed to do that. So, fixing it, I have no problem, I can fix it, but you know the result. In light of what I have said this morning.
Well, there are two things. I would not want to go into this decision.
No, of course we are not supposed to.
I'm not supposed. It would be unprofessional for me to go into whether you have jurisdiction, because I would then say there's unlimited jurisdiction. I don't want to go into this. But again, you have the powers to transfer this file if you believe it is not proper for you.
I thought you also have the responsibility to file your matters in the right court.
My Lord, ante this decision, we knew were properly before you. And we still believe.
So what do you want me to do with the other application, the bail application?
It may be.
Okay, I can give you a date.
Transferred. Yes,
Yeah, I can give you a date for it.
then we can meanwhile
Yeah.
make a decision on this.
Yes, no, we have no problem with that.
You have not been served.
We have not, yeah, that's what I was going to make my case.
You cannot have any
Yeah,
problem.
so we haven't been served by law.
My Lord, just a simple clarity. Especially putting in mind that this honorable court has jurisdiction. Because of not resting,
Don't take me there.
most blood. My humble prayer would be, instead of fixing the matter, because we had already fixed the main suit, this honorable court still has the authority and the powers, if possible, to transfer the file to the other side, so that at least that case is handled that side, and we proceed with the main cause, Your Honor. Instead of now fixing it, then coming in for hearing and all that.
Now you see, because you represent different people, you are beginning to
Yeah.
fight among
Exactly.
yourselves.
Because the mind about other accused persons before this honorable court?
No, so I'm giving them a close by date. And yeah, I can actually ask both of you to come. We believe you have not been served so that we resolve this.
Yeah, let's mention that matter before you first have direction on the same. Mention.
Can put it to touch Monday next week.
Well, formation we shall take it, but not, I know.
No, actually, I'm going to give it again right now. So you can pick it and serve it again.
Yes.
Yeah, and I expect them to come on the touch, even if they have not found the legal.
Yeah, I'm saying let's put it for mention. 10 of us can be around, so the date will suffice. Let's just mention
Okay.
that we are on that date. And my clients wanted to state anything, it's within the powers of the honorable court. Decide whether to hear them.
Okay, I'll fix it for mention on 3rd of October at 9:30.
Mr. President,
The day after. Mr. This is the double Z. Does any of the clients want to say something? I give the Honorable Ssewanyana, please.
Thank you, Your Lordship. Your Lordship, we have just received disturbing news this morning from our lawyers that you have made a decision to hear ex parte an application for witness protection from the state or from the prosecution side. Mindful of our status, mindful of the kind of jobs that we do, the worship. We get these jobs through a competition. We have enemies as members of parliament. We know that anything can happen, especially in regard to witness protection. We have people in our constituencies who lost jobs in favor of us who became members of parliament. We go through a competition, a competitive process.
Those ones who supported you?
Those who supported us and those who did not support us, they are all there. So we are very mindful of why the state is asking for witness protection, because he can do anything, can get anyone, any of our competitors to come to court here. We are very mindful of that, your worship. So that's why we are given orders to our lawyers to be party to that application and make substantive arguments in favor of us as they are chosen. We don't fail to be having a fair trial if the ones who are going to give, who are going to be witnesses in our case, are going to be protected, are going to be closed from us, and the public are going to be hidden.
I can cut it short.
Yes.
I can cut it short and tell you that I don't know whether your lawyers shared with you the ruling that I made. If they do not, then they should, so that you get to know the reasoning why I say that application should be experted, because the law allows actually provides for mandatory expert application. But to array your fears is that the court has not made any orders yet in that application. And that is what we are going to listen to from them. And court, you just be comforted that court cannot, you cannot allow you to be tried by ambush. That application that they have sought, which is expected, is for me to determine whether they should disclose to you when and how. Have you got it? So they have not allowed them not to disclose at all. I am going to assess their arguments and then I will make a decision. So you don't have to be worried about that.
Thank you very much.
Okay. Honorable Ssewanyana, is there anything you want to say? Okay. Okay, I wish you a good day. And I will give you a ruling that sign off of the ruling in the next 30 minutes.
Give us away.
Going.
Kisazi ekikulu. Now you put it on board.
Tagana ndikwate.
Bagonze omutima baana bano tebalina musango batukuluvu tebalina musango gonda omutima baana bano basumulule bafeeyo kuba balina be balina okuweereza naye abaana bano babonye tegera
Dona antumye gy'oli.
Yetazala wena bakumbera mumbera bwe simena kumanya Bagambe buli ali mu kkomera yabba
Mazima go ge gakusibya.
era kye batugamba kyonna kye kijja kuggwa Ssegirinya ajja kuvaayo
Obaddi
bonna bajja
gamusibya. Ssegirinya tasobola adda ngasobola n'okukola eddwaliro ejjanjaba omuntu. Ate asobola okutta abantu. Balenga mu magezi. Omusajja yadduka nga mumulala n'adduka n'agenda wa n'agenda omuntu ayagala okutta omuntu agula n'ambulensi ewonya omulwadde. Ate banekubere siriyasi. Olw'okuba ayagala enkyukakyuka n'omukulembeze we ekimutuusa ku nsonga eyo n'okukola ebirungi by'alina okukolera abantu. Naye ke tukimanyi kijja kuggwa, kyonna gye kiri kijja kuggwa.
Bateekawo embeera nti bakukyayisa abantu.
Naye tusiba tukyamwagala tukyayimiriddewo naye mu buli mbeera. Ene tayimu mujja musesema. Okwogera
matter in Masaka, now in Masaka, the matter now at the ICD are more or less the same. The charge of murder in Masaka arising out of the Greater Masaka is the one still being held in Masaka. We also have charges of murder here in the ICD. So we believe that these are same offenses which can be joined under one file to avoid a constitutional obligation to court to avoid double jeopardy and the right to fair hearing. What we've heard today his court has told us that it does not have that unlimited jurisdiction. That this High Court here at the ICD is different from the High Court in Masaka. I think this is a matter even a law student will be puzzled about. I think the law is being changed. The law we know that the way we know it from the Constitution, the High Court has unlimited jurisdiction. The High Court in Masaka and the High Court here are the same level. It's not about the persons sitting on that bench, but we respectfully are going to look at this as a matter of law that we may need to really find a way to go through the records of court. That's a decision to be made with our clients, because we have to balance their rights of being inside prison and going to another measures that can delay us further. So it's not a decision I can make before I consult, but we do not want such a decision.
So, Council, now
the issue of bail and another
Again,
issue.
it affects, this decision means that even our bail application before this Honorable Court may be improperly before this court. If the other file cannot be consolidated here, if this court believes it cannot hear matters relating to the file in Masaka, we think then it is two positions. The previous judge had such an application as a matter of rights arising out of the other file and even made a decision. Now we are getting a conflicting decision. It is in such cases where we find two different positions from judges or judicial officers at the same level making the two different opinions or decisions. It is such decisions that call for us to go to a court of the higher court to harmonize the position. So these are all matters we are considering. Are we really properly here? Shall we be proceeding properly as council? Should we allow courts to affect the rights of our clients? You say this is not right, you even go to the extent of saying that there is no abuse of legal process. So I can be held on account of murder today by this court. I'm released on bail, and then I'm again taken into a drone and brought back even 5 times, and you say there is no abuse of legal process. I think really we should do better as the judiciary in managing these matters, especially public importance. But respectively, most of them are matters of law. We need to handle them as lawyers. We just need to have a review of them or appeal against them. But that will be on the instruction of our clients and other colleagues on the bar.
So, please explain in simple English. When the judge said that a joinder is allowed and the consolidation is not allowed, what does it mean?
No, the judge said she can join the counts or charges, but she cannot force another person who is added onto the accused persons on the other file to come before this court. That person will be a stranger before this court. Again, we disagree, because then the state may just come up with similar charges, just add one person, put you another court, add another person. I think the laws under which we move give the leverage to this honorable court, especially under the Constitution, to ensure that we protect their right to fair hearing and in all circumstances. Otherwise, the state can continue even tomorrow, manufacture another case, add only one person, and say, no, we cannot join those counts since the individuals are different. These are murders in Greater Masaka by people or offenders in Greater Masaka. The court of Greater Masaka is the High Court of Masaka, which handles matters of them. So, well, it perturbs us. We think it's not a proper decision. We may need to determine whether to challenge it, but we shall respectfully understand that that is this court's appreciation of the law, and as lawyers, we are bound to respect that decision going forward. Twajja mu kkooti eno nga tugamba nti emisango okubeera nti abasibe bano balina fayiro 2 ezifaanagana, zonna omusango gwe babavunaana kumpi gwe gumu, omusango okutta abantu mu Greater Masaka, nti waliwo abantu abattibwa mu bijambiya Greater Masaka. Greater Masaka mwe districts omuli Masaka Lwengo
era kooti etwala ebbendobende eryo e high court y'emasaka ekyawuka ku musango gwaleetebwa wano nti bagongerako terrorism ewulizibwa kooti ICD kyekyokka ekyawuka n'ebirala byonna bisoma ng'ate mu mateeka kikkirizibwa okuba nti omusango guli gwa mada guleetebwa ne gugattibwa ku fayiro eno naye omulamuzi atugambye nti mu mateeka tekikkirizibwa kugatta bantu bali ku fayiro bbiri nga tebafaanagana mu fayiro eno nti engeri eri gye kuliko Ssennyonga ne bakono ebwana babiri naye nga fayiro eno Ssennyonga taliiko tasobola kukaka Ssennyonga nakaka kooti eri kuleeta Ssennyonga wano ng'ate alaba nti bali ku level y'emu n'omulamuzi w'e Masaka tamulina ku buyinza ffe tugamba nti kooti si mulamuzi atudde mu ntebe constitution egamba high court erina unlimited jurisdiction mu nsonga zino kitegeeza high court oba eri Masaka oba etudde wano it is the high court kyetwaki ne bail application neziva mu guli omusango twali tuzireese wano ekizibu kye tufunye kitegeeza nti ne bail application tayagala kugenda mu maaso kati ekiba kyongera kuyingiriza ddembe ly'abasibe naye ekyokuba nti agambye tekimenya mateeka okuba nti kooti emu esumula omuntu ku musango gwa mada nemuwa kakaluka kooti nemuwa beeri kooti yemu ate neddamu ne bamukwatira mu luggya lwayo drone nemukomyawo era ku musango gya mada nagiri bamuwaddeko beeri ne bamusiba n'ogamba nti embeera eyo yaliwo temenya mateeka ensuubira ekyo sikituufu tugenda kusalawo ngeri ki oluvannyuma lw'amateeka atumaze okwebuuza ku basibe ne baloozi tujjukira nti nno twasala mu kooti eno twatayo bail application nga twagala bateebe kakaluka kooti naye okusinziira nga kooti eno bwesazeewo mu nsonga eyo tukkiriziganyiza nayo tukoma okunaku lwokusooka tusalewo nti okusaba kwaffe okwokweyimiririra bano abasibe nga tutunuulidde ensala ya kooti olwaleero okugamba nti teyagala kuyingirira mulimu gwa mulamuzi atudde Masaka alina fayiro eri kuba fayiro tebeera mu nkwawo ebeera mu kooti naye bwaba bwatu bakisazeewo tugenda kukomawo tukutaanye ku mandi tusalewo oba tusigala wano tusaba okweyimirirwa oba tugenda mu maaso n'okugenda e Masaka okulaba nti tuddamu okusaba okweyimirira kw'abana bali mu kooti okuva mu kooti zo decision tugenda okukola wakati wa kakati embalo
Kusirikiridde nnyo naawe omuntu tumusiriikiridde ebbanga lyonna nakusiriikirira nakusiriikiridde ebbanga
the one for witness protection and this one for consolidation. Where do you see the future of this case?
As lawyer, we are mandated to act for our clients in the best interest of justice. So we shall not relent, we are not going to give up. We know that we have to keep on pushing and trying until justice is achieved. Moreover, we still have avenues of challenging these decisions. So we are going to sit as a team and also consult our clients and see whether we can appeal or apply for review of these decisions.
Court says that being tried in two courts does not in any way contravene the level of justice as in Article 28 of the Constitution. Do you agree with court?
Well, the court is entitled to its opinion, but there is the law, and that's why we are dissatisfied with the decision, because we are saying that this is a duplication. It is an abuse of the process of law, because she agreed that the offences arise out of the same series. They are all related to the murders and massacre. And now, if she says that we cannot add them because the parties are different on the two separate files, we feel that it's absurd, and those are some of the issues we are going to address as a legal team, and also consult our clients to see if we can appeal against them. ffe nga bannamateeka tulina obuvunaanyizibwa okukiikirira baclients baffe okulaba nga amazima n'obwenkanya kuvaayo. N'olwekyo okuba nti application y'okugatta emisango oba eya witness protection okuba nti twagaaniddwa okuba nga tuzirabako tekitumalaamu maanyi, kubanga nga bannamateeka tukyalina omukisa okuba nti tusobola okukyalenjinga oba okuwakanya ensalawo zino nga tugenda mu kkooti ezisingako. Ate era nga bannamateeka tugenda kutuula nga bannamateeka wamu nga tukonsalitize n'abaclients baffe nga tumaze okwogerako nabo tulabe bwe tusobola okuwakanyamu ensala zino naye nga tetugenda kuwanika.
Wena ali ku Ssewanyana Uganda media tugenda kubanga tukwerekerera naye nga babazizaayo obadde ne Bobi ku kamera akumye atakumira mpeera bye bye.